you can hear
Yeah,
me.
let's have
Based on where I am, it's kind of a little bit difficult to have my camera going. So is it okay? Can I get an exception to this?
yeah, that's fine. I just you've already come on camera. I've seen you. That's fine. So just to help your bandwidth, why don't you just keep your video off?
Yes.
Excellent. So the two allegations that the landlord is claiming is that there's arrears owing, which means the tenant hasn't paid rent, which he is obligated to do under the tenancy agreement, and that amount owing up to today is $37,802. So my first question to you, representing the tenant, is the tenant disputing this? Does he acknowledge that this is the amount of money that he owes?
Um, no, he's disputing it.
And what's the
So
dispute based on?
so we're going to be doing a little bit different today because we're operating from an Indigenous jurisdiction. So my presentment is pursuant to Section 82 of the Residential Tenancy Act. The tenant raises an issue, a constitutional validity of the proceedings before the tribunal. Under the provision of the following statutory protection, pursuant to Rules 37 of Civil Procedure, in accordance with Section 109 of the Ontario Court of Justice Act, the tenant argues that the process under the Residential Tenancy Act lacks jurisdiction and violates their charter and rights of freedom to fair procedural fairness under Section 7 and discrimination under Section 15. All men are equal in the eyes of the law and must be treated fairly by all means necessary. Pursuant to Section 24, subsection 1 of the Charter, the tenant drafts a notice of constitutional question under Section 109 of the Court of Justice Act of Ontario. The tenant served a notice of constitutional question to the Attorney General of Canada, the Attorney General of Ontario. This notice was served to both offices at least 15 days before today's hearing. The LTB also was informed about this notice as well. The Attorney General office have not responded as yet. Since the LTB does not have judicial independence under Section 96 authority under the Constitution, in accordance with the Constitution Act of 1867, the tenant requests this proceeding to be stayed until the constitutional matter is addressed in the Superior Court or a court of competent jurisdiction. In accordance with Section 109 of the Ontario's Court of Justice Act, the Attorney General must be notified of the hearing when notice of constitutional question are served, and any further hearing proceeding shall only be heard if the Attorney General sees fit. The Attorney General of Canada and Ontario are responsible to bring forward evidence to make submission to the court venues and tribunals in respect of the constitutional question. If the Attorney General offices have not responded to the notice, silence is acquiescence, and that means the tribunal or court venue shall not have inherent jurisdiction to proceed. The purpose of this section is to ensure procedural fairness and to give government entities such as the Attorney General an opportunity to uphold their fiduciary and defend the statutory protection set in place to protect the people and to prevent lower tribunals and other court venues from violating fundamental and statutory protection as guaranteed by the Canadian Charter on Rights and Freedom, which stands as the supreme law of Canada, and all statutes, codes, and acts are bounded thereby, pursuant to Section 52, subsection 1 of the Constitution Act, safeguarding liberty, equity, equality, and justice in Canada to ensure constitutional challenges are properly argued with full participation from the Attorney General. So that's my submission for now. We're challenging the jurisdiction of the board.
So you're claiming this under 109 of the Ontario Court of Justice Act. What is the claim?
I am not sure if you're able to see in your records, but the notice was filed with the board as well, and along with an affidavit of service as well, to prove service on both Attorney General in their respectful capacity.
Okay, well, let me go into the file and see that. I didn't. I looked the file over several days ago, so I didn't see it there.
Yeah, I think Ian may also have a copy of that as well, along with the affidavit of service as well, with the applicable date on there to reflect when it was done, along with the registered mail from Canada Post. So the attorney, the Postmaster General is also third-party witness to the services.
And sorry, when was this filed? Because I'm in the file right now. I don't see the notice.
So it was filed around the I think it was around the 10th or the 12th. I'm not sure. It was around that time and where it was put forth.
Okay, one moment. There's a couple of documents that are.
I can give you the evidence ID numbers.
If you can, that would be great, because unfortunately my naming convention is very generic when the staff put it in there.
Oh, okay.
No, I got it right here. I'm good, thank you.
Okay.
All right, Representative Quarzada, would you like to make submissions?
Yes, so I actually also have a landlord's factum uploaded. It is in response to their disclosure, evidence ID number 546-4252. So in short, I can elaborate if you want me to address everything he has just mentioned. But in short, they've raised a series of constitutional, sovereign citizen, and pseudo legal claims that are entirely irrelevant and unsupported in Canadian law. These include ideas about lease monetization, jurisdictional immunity, and invoking UNDRIP and the charter inappropriately. They also state in their notice of constitutional question that the Landlord-Tenant Board has breached their fiduciary obligation, which is not the case, as the LTB hasn't even made a decision yet today. And they also state that the LTB doesn't have jurisdiction to adjudicate on rent arrears and rent eviction. However, the sole purpose of the tribunal is to enforce eviction and rent arrears. So we completely object to this notice of constitutional question. We believe it's without merit, and it should be thrown out. If you want me to go into depth with case law and arguments and stuff like that, then I can do that as well.
I would like you to submit the case law for me so that both Chief Micheal and Ian, who is present here today, can hear that as well. They can make reference to that. Go ahead.
Okay, perfect. So on jurisdiction, the tenants have argued that this board lacks jurisdiction under Section 96 of the Constitution Act 1867. This argument is wholly without merit. The Landlord-Tenant Board is a specialized tribunal created by statute and has full authority under the Residential Tenancies Act 2006 to adjudicate on this matter. Tribunals have been granted jurisdiction repeatedly by the Supreme Court of Canada in a bunch of different cases, including the case of Ocean Port Hotel Ltd, First British Columbia, 2001, and going on to lease monetization and sovereign citizen claims. The tenants have claimed without evidence that the lease was monetized or transformed into a financial instrument. This is a well-known pseudo-legal tactic with no legal basis in Canadian law. As the court held in Meads versus Meads 2012, these organized pseudo-legal commercial arguments are legally meaningless and should be treated as such. The landlord never attempted to turn the lease into a bond or security. This is a fabrication and it has no connection to the facts of the case. The lease attached, which is evidence number 5464250, shows that the landlord is using a standard Ontario residential lease form, which was signed by the tenants. The tenants signed it willingly, they paid rent under it, and then abruptly stopped paying rent after September 2024 without any legal justification. To add on top of that, their claim is basically, in their notice of constitutional question, their claim is basically that after the first and last month's rent, somehow the lease agreement was monetized as a bond/international bill of exchange, the proceeds of which have not been equitably returned to either party. However, this makes absolutely no sense because first month's rent was paid for June, which means second month's rent was paid July, and then another month was paid in August. They stopped paying in September. So if they believed that they were only subject to pay first and last month's rent, then why did they pay July and August? That just does not make sense. It contradicts their whole claim here. Now, on the Charter of Rights and Freedom claims, the tenants have cited Section 715, Section 1 of the Canadian Charter of Rights and Freedoms without any specific allegation of a violation. There has been no infringement of procedural fairness, no discrimination, no government action infringing on life, liberty, or security of the person. As clarified in Tenud Jaja versus Canada Attorney General 2014, there is no constitutional right to guaranteed or free housing. An eviction under provincial tenancy laws are not a breach of charter rights. Moving on to Section 35 and UNDRIP claims. The tenant invoked Section 35 and UNDRIP attempting to suggest these override the RTA. These provisions apply to Crown or government action, not private tenancy agreements between individuals. This rental unit in question is not on Crown land, and no Indigenous land claim is at issue. As such, these references are entirely misplaced. On the TRC calls to action, the tenants reference the Truth and Reconciliation Commission's calls to action. While those are very important national policy considerations, they're not legally binding documents. They are policy. And do not provide a legal defense to non-payment of rent under a private lease agreement. The tenant has failed to provide any valid legal basis to avoid paying rent or to prevent termination of this tenancy. Their arguments are an attempt to delay eviction and avoid financial obligations. The law is clear. Tenants must pay rent, and landlords have a right to seek eviction and recovery of arrears when that doesn't happen. And we believe that the LTB today should affirm its jurisdiction under the Residential Tenancies Act and dismiss the tenant's constitutional and pseudo legal arguments as unfounded, irrelevant, and without merit. And once the hearing is heard, then to order an eviction order, rent arrears, and utility arrears. Thank you.
Okay, thank you. All right, one moment.
Do I get another opportunity to speak again?
Yeah, I want to look up just a couple of things here. Well, Chief Micheal, I'll afford you an opportunity to speak, but I'm not sure it's necessary. Given everything that's before me, Chief Micheal and Representative Corazada, as I stated earlier, I was canvassing parties to see where I was at because the block time does end till 4. I don't think I would have enough time to hear this with all of the submissions, further submissions on this to make a determination today. So I would likely have to adjourn this anyway because I'm probably going to need at least another 25 to 30 minutes for the file that I'm on to complete. And then there's one other damage claim that I heard earlier. So Representative Carzada, it does not look like I would get to this anyway, and I would likely have to adjourn it, but I'm willing to hear submissions on my consideration.
We completely understand. Obviously, it's not ideal because the arrears are very high at this point, exceeding the jurisdiction of the LTB. But we do understand stuff happens. We have technical difficulties, all of that. So we do accept. We have no objection. But can we get an interim order in the meantime that they must pay rent?
Yeah, I was going to actually ask Chief Micheal a couple of questions as well. So let me take that. I've noted that here. Just give me one moment, okay?
Perfect. Thank you.
Chief Micheal?
Yes, Mr.
You can just call me Adjudicator Buccaneer. That's fine.
Yeah, all right, no problem.
Yeah, thank you. So as I stated, at this usually around 3:10, 3:15, I start to canvass parties when there's a few files left, just to see where I'm at. Hopefully, get through everything. Doesn't look like today I'm going to. This one would be one that I would likely have to adjourn due to a scheduling overflow, considering I have to finish the one I'm on, and there's one more that I've already canvassed that seems just to be a damage claim that I could proceed on. Having said that, Chief Micheal, based on what you provided for me today, is the intent of the tenant to stay in the rental unit rent-free?
Well, to be frank with you, in accordance with contract law, it's stated on the face of the agreement that first and last settle the agreement. So I would like for someone to explain to me how can there be contingency in a settled matter. And based on the representative for the landlord arguments there that the tenant were paying the rent up until a certain amount of time, you know, everyone has the rights and the responsibility, and it's their obligation to stop the fraud when they realize that they become a victim of fraud, because as you stated, ignorance is no excuse. So if one's knowingly participate in fraud or unknowingly participate in fraud, that makes them also liable of committing fraud. So at this point, you will have realized the deficiency within the agreement. Secondly, the property is on unceded land, which are ancestral territory. You know, the people of the land are realizing who they are and who their ancestors were, and it is quite disheartening, to be frank with you, for once to be taxed on their own land. Apologies if you lost me there. My phone was ringing. I'm not sure if you guys can hear me.
I heard everything. I heard a small beep, but it didn't impede what you said. I heard everything.
Yeah.
Can I just ask two questions?
Actually,
sorry, Representative Carzada, hold on. As you've seen today, I afford all parties equal representation. So let me just hear from Chief Micheal.
Yes. So, and as I stated before, that the tenant is Indigenous, and of course, Canada is a signatory to the UNDRIP, which is the United Nations Declaration on the Rights of Indigenous People, and of course, Canada has the protection under the Charter and Rights of Freedom to protect the Indigenous people and all persons, even citizens, corporate states, or corporate entity that are under that 14th Amendment contract.
Sorry, Chief Micheal, my apologies for interrupting. So the tenant intends on staying in the rental unit?
Yes, the tenant intending on staying in the rental unit, and can you hear me?
Yes, I can.
Yeah, and we're looking for the matter to be heard into a court of competent jurisdiction. And you may have known by now, I have been, doing work supporting Indigenous tenant in the Landlord-Tenant board for quite some times now, and pretty much that has been the argument. And even when our adjudicator go and overreach their jurisdiction, I find ways to hold them accountable in other.
Well, again, I'm not bound by any other members' orders. I just want to know what the tenant's intent is. If it's to stay, then I need to make a determination if I'm going to grant the representative the request for interim order for rent. So, Representative Carzada, you had a couple of questions. Go ahead.
Yes, I have a question. I have a few questions for the Chief Micheal. First of all, where is this contract that you keep speaking of that says he doesn't have to pay rent?
Well, again, that's going down the merits of what I would need to make a decision whether or not to proceed on the application, which I'm not prepared to do at this time, given the time.
Okay, it's like for speaking towards my interim order request. There's a lease on the portal here uploaded, signed by the tenants. So just just for your knowledge.
I will look at that, and you're aware that even if I do issue the interim order, it doesn't sound like the tenant would comply with it anyway. So I'll make that decision tomorrow when I sit down to review the file and look over the order. So for Chief Micheal and Representative Kwarzada, I will be adjourning the hearing. Let me just call this into record officially. This is docket number 4. The file is LTB-L-097926-24. The unit address is 45 Magnolia Avenue in Tottenham. The landlord applicant on file is Yujaval. I'll use last name. I hope that's okay. Katri. And I have legal representative Maria Kwarzada present here today. Respondents on file are Ian Clark and Annie Clark. I have Ian Clark present, and the tenants have a representative, Chief Micheal, in attendance for the tenant. I'm going to adjourn this due to scheduling overflow, and the time of the hearing is 3:19. Parties have made submissions, and I will include all these notes in my adjournment sheet.
And just before you go, Mr. Adjudicator, I don't mean to interrupt, but I have to also let the representative for the landlord know as well that we're not sovereign citizens. Those are people who are committing
Chief Micheal, I don't need to have any submissions because I'm not going forward on making a decision if this is properly before the board's jurisdiction. So you can save those for another submission when this comes back. But for now, I don't think there's anything else I require from either party, so I can move on and address the other dockets.
All right, no issues. I will see, whoever it is that's presiding over the next matter. So I will be there and prepared.
Okay, thank you for your submissions today, Chief Micheal. Representative Kwarzada, thank you very much for your submissions. For both of you, I'll have my adjournment sheet posted on the portal sometime after 1 or 2 o'clock tomorrow in the afternoon. In the meantime, what I am going to ask both parties to do is provide the board within the next 48 hours of any unavailable dates the parties may have. This would include any vacation time, work, or medical commitments. Okay, this will be adjourned by the board and a new notice of hearing will be issued out.
Thank you, will do. Are you seized on the matter?
I am not seized. I haven't heard any merits with regards to the actual applications, although the submissions on whether or not it's properly before the board. So I'm not seized based on what I've heard to date, and it would be better to be put back in the queue by my adjournment sheet. But up to now, I'm not seized.
Okay, thank you.
Thank you very much.
All right, full enjoy the rest of your day, Mr. Adjudicator.
Thank you very much. Okay, parties, 1 second. Just let me update the docket here.